let's take Mike, who's been on trial for DWI. The testimony was that he is a beer distributor. He was calling on a client. He was there for an hour. He had 2 beers, the proverbial 2 beers there, left, pulled over for speeding, did fairly well on the SFSTs. There was no slurred speech. He flunked them, with 2 clues on the one leg stand, the walk and turn, and gaze. And was taken to a police station, blew a 1-4, and was there for 3 hours. Never left the eyesight of the officers, never went to the bathroom, never asked to go to the bathroom, and was then released. The defense expert testified that for someone of Mike's weight to be a 1-4, they would have had to have the alcohol equivalent of 12-ounce bottles of beer. And the testimony was he was drinking beers. 12-ounce bottles of Coors Light beer, the alcohol equivalent in his bloodstream at the time he took the test. So that's our case, all right? So let me ask you how you would start your summation. Before I do that, okay, understand there are no right answers. I'm going to be telling you about my experience and the things that I've learned and stolen from other people throughout the years. But the key is, this whole program is like a clothing store. You come here and you take the things that fit you that will work in your jurisdiction. Like you heard that introduction that Steve did? Okay. Steve's from Tennessee. Okay. Manners are really paramount in how you talk to your parent. I'm from upstate New York. I grew up in Grand Gorge, New York, population 500. All right. I mean, I had to be taught how to buy clothes. A state trooper, and as a prosecutor, taught me how to buy clothes that matched, because the first time he saw me, he said I looked like a Christmas tree. Okay. So, manners have been a real hard acquisition for me. But that's one thing I've noticed about being here, about being in the college, and about all the different people you run into. Just talking to them and seeing their personalities gives you a real reflection of where they're coming from and what the population, what the juries are like, because you can tell by the way they, like the speakers, the way they lecture, people you run into, by the way they talk, all of it. So when I talk about starting your summation, it's how you start based upon your experience and what the population that you have. So given that kind of a case, how would you start that? What would be the first words you get up and start saying to a jury? Okay, start off explaining that he was at work doing his job. How would you start off? All right, I'm saying the exact first words coming out of your mouth when you get up in front of the jury. Oh, wait a minute, back. Would those be? They would not be the first word. What would be the first word? I'm looking for the first words. Would it be, members of the jury, I want to thank you, or what would it be? It would be something to do with your theory of the case. 12 bottles of beer. Okay. Well, the testimony is he was there for an hour, so yeah. That's be drinking a beer every 5 minutes. It's quite a challenge. But we're off all afternoon, so, All right. Yes, Mike. Okay. Mike took 12 bottles of beer, poured it into a big container, and put that up and said, you want to look at it? And this guy never peed. Okay? So the urine defense, Okay. All right. The theory of your case, and depending on where you're from, what you can do. I went to a class 30 years ago. Okay, virtually everything it's not so much original thought with me, it's stealing, basically so. 30 years ago, Darrell Dantzler was the dean of the National Criminal Defense College. And when we all got there, first it was like 1987, she got up and gave this talk on cross, but the principles that she covered in that lecture have stayed with me for 30 years. I used the stuff I learned at the college, but the interesting thing is the lecture that I remember most was that lecture by Dean Dantzler as to cross and all the principles she gave. So I'm going to be telling you a lot of stuff that came out of the National Criminal Defense College, and particularly from Daryl Dantzler. All right? We have, right now, a magic moment. When you first stand up there, everybody is riveted. I mean, look at you right now. We just started in the beginning of this thing. I don't see anybody yet on their cell phone. Okay? You're not even looking at the computer. You got work to do. What are you doing? Okay? You are wasting valuable time listening to me. And you can be getting that stuff done. But I've got you for a minute. I've got you for the minute. I'm not going to have you for long, but I got you right now. And that's what's critical about that magic minute. When you first get up in front of that jury, they are going to retain the first thing that you say. Okay? That is that magic time that you have. And that could be, for a lot of lawyers, because they feel it's necessary, ladies, members of the jury, I want to thank you for the time and concentration you put into this case. You're shaking your head no. I agree with you. I would never do it. But people do it. And if you follow Dean Dantzler's, what she says about primacy and recency and primacy, then they're going to remember that you were concerned about their time. Okay? For me, I'm with Mike, I'm with you. 12 bottles of beer. 12 bottles of Coors Light beer. That's what you have to believe, what you have to accept, blah, 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 in order to convict, et cetera, okay? That's where I'm going to start, and that's what I'm going to finish with in that case, all right? Because that 3 hours, he didn't ask to go to the bathroom, et cetera. And by the way, all of this stuff doesn't get set up at trial. If you get pretrial hearing, how many people don't get a pretrial hearing, just got to go right to trial? So almost there are people who don't. Okay. All right. That's different. The advantage you've got is that the prosecution doesn't know what's coming either. Okay. The pretrial hearing helps both sides. But for us, with that pretrial hearing, we get all this stuff set up. So I've got them locked in. I got a transcript, and I now have them locked into that testimony from the pretrial hearing. And that helps a lot. So I've got that bathroom thing locked down. All right. So the theory of your case is what I would advocate that you want to come out with first, and that in this case would be the 12 bottles of beer. That magic minute. I'm going to talk about pauses later. But if you want to emphasize something, if you want people to look up and stop working on that computer, stop talking. Get comfortable with silence or with pauses. He's programmed. When he was in 3rd grade and he was talking, because he was, okay, he was, the teacher would stop and he'd notice suddenly she's not talking, he will look up. You get their attention. You want to emphasize a point, you want them to retain that point. Pauses, saying nothing, but you have to discipline yourself, because when we're up like this, either doing this lecture or in a courtroom, we're loaded with adrenaline. Okay, I think I love the lecture because I'm an adrenaline junkie. But you're loaded with it, so it impels you to talk fast, or it impels you to fill a vacuum of silence. So you need to get comfortable with silence. But that is an incredibly valuable thing to use in a summation opening, or even in a cross. When you want a point to resonate with the jury, you just stop, and they'll all focus on you. Start strong. That primacy and recency is a theory that I first heard back 30 years ago, and that I've heard ever since. People remember the first thing that they heard and the last thing that they heard. So that being true, you want to start strong with your summation, which again is that 12 bottles of beer, and you want to end strong, coming back to how you started, and then you fill everything else in the middle. But you need to know what you're going to stand up with, and you need to know what you're going to sit down with. And standing up with it is a lot easier than coming up with what you sit down. In this case, it's pretty easy because we got this guy who's got to pee. And that, you do this right, and that jury is going to be dying to go to the bathroom, okay? People remember what they feel. It is not what you know that influences you as a human being. We overestimate knowledge tremendously. It's what people feel. We use knowledge and logic to explain and rationalize what we've already emotionally concluded, okay? But information has very little. If information and knowledge had much influence in human affairs, we'd have no smokers, no one would be overweight. Our clients, I've got clients who could write a doctoral thesis on alcoholism, but they can't stop drinking. They can't stop drinking because they are not emotionally committed to it. What you know doesn't do much. So knowing that in the courtroom, we want somebody to remember something. We wrap it in an emotion. We make them feel. The 12 bottles of beer and that 3 hours is potent because it makes you feel that concept of having to go to the bathroom. Everybody has that. We're all running to the bathroom on breaks, etc. So the idea of 3 hours and after drinking 12 bottles of beer, no way. No way. But they're feeling it. It's not just an appeal to logic. So anytime you can do it. I mean, the biggest illustration of this is I can't remember names. I can't remember a whole bunch of things. But I've got friends, they hear a joke once, they got it forever. Why do people remember? Do you tell jokes? Yeah, but you tell them, right? Okay. And you can remember them. Okay. Why do we remember them? Because they're wrapped in an emotion. Humor, laughter, they make you laugh, and you can retain it. So that any way you can structure that summation so that people feel, that's what they're going to retain. Because it's not that moment. It's not right now that you're concerned about. It's a couple of hours and 3 hours, 4 hours from now when he's in that jury room. We want him arguing for our side in that jury room. We need to give him concepts that he'll retain. And he'll retain things that make him feel. That's what we're looking for. Because no matter how dramatic, no matter how great that summation is, no matter how much style, whatever, that's all worn off after 3 hours. But the points that were wrapped in emotion, those are the things that are going to be retained. And that's where you get your advocates in the jury room to win your case for you. Talk to them. This is so hard, because you get up there and there's the formality of the situation, okay? And it's even worse because they're all sitting there. How many of you have ever been served on a jury? Okay, so we can call a jury. The thing that I remember is as a lawyer standing up, I think of the people in the group as a kind of a cohesive body. Like right now, looking at you guys, it's a group, it's kind of cohesive, etc. And a lot of you do know each other. But for a jury, for the most part, they don't have a clue, unless you're from a real small town. I picked a jury in Shelter Island, which was a blast and a half, the little island, on Long Island. And everybody knows everybody. They knew the cops. I had jurors saying, I would never believe anything he said. He's a liar. Everybody knows that. It's like, oh my God. That was the first time I ever had a DA looking for a mistrial. Okay. But for the most part, they're not. And they're sitting there and they're nervous, okay? They're very nervous. They're concerned about how they look. They don't know any of these people. We're going to be asked questions, and I got to know what the right answer is. It is not a case of giving you what the real answer is. It's what the right answer. You have to be aware of that they're not a cohesive group, and that you need, by what you do, to try to warm the atmosphere and try to make them comfortable so you can get meaningful answers. Also, if you can warm it with your personality and with your being, real, they relax. You've all had the experience dealing with, I'm thinking like a clergyman right now, but somebody that is, warm and friendly, but there's a formality to them. You know what I'm talking about? Okay? And they kind of speak in platitudes. They don't really say anything. What happens when that happens with you, you automatically assume the same demeanor. If he's not open, if he's dealing with me arm's length, even though the expressions are friendly like that, I'm going to be fairly formal and withdrawn as well and come back with platitudes. Same thing with the jurors. If you assume a professional demeanor, because you want to look and sound like a lawyer, okay, not only are they not going to be, forthcoming with you, aside from hating you in addition to everything else, but they're not relaxing. One of the hardest things to be is yourself. It's very difficult, particularly when you're put into a formal situation and you've got a judge, you have an opponent, and you're in there and, you're in your suit and all of that. It's very hard. But when you do it and you get a response from somebody, okay, like lecturing, I'll get a response, and it warms the whole atmosphere, relaxes him, relaxes me, and then you can talk. And if you can get to that level, they'll talk to you if you talk to them. And the voice you want is the same voice you use when they're the friend and family voice. And that friend and family voice is a voice that has credibility, that people will believe. There's nothing being hidden. There's no artifice. There's no formality, okay? I'm not saying, use informal language necessarily, and you've got to be very careful because you have, I learned the lesson, because everything with me is 25 and 30 years ago. It's kind of scary. Jeez, But like Steve said, I do a lot of lecturing. I love the sound of my own voice. I really do. And so I take every opportunity, because where else? Nobody's going to listen to me in there. My wife and kids aren't going to listen to me. The only place I can get listened to, is, when you get the lecture, okay? But all in the criminal defense, field, we're profane. I don't know why it is, but we're very profane. You know what I'm talking about? No, I don't know what you're talking about. I'm not profane. I don't know who you're talking about, but not where I come from. But let's put it this way, New York criminal defense tends to be profane. So I gave a lecture, out in Buffalo, and you get the evaluations. We study those things. Oh my God, if you really want to wound somebody, you write a negative evaluation. I'll hate you forever, but still. One comes in and said, it's a shame that someone as articulate, blah, 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 as Mr. Gerstenzang, can't express himself without the use of profanity. And that hurt. That hurt. That was the last time. If I use profanity now, it's purely by accident, but I'm not letting it happen. Same thing when you're dealing, you have to be sensitive to the differences of people on the jury. You may have some guy who's very religious. You may have somebody who has other sensibilities. You have to be aware of the diversity of personality and background on that jury and make sure that you are not offending that. Group dynamics. One of the biggest problems that we all have is this public speaking aspect of it. Doing an opening, doing a summation, getting up and doing a lecture. It's the most common fear that people have. First time I ever did a lecture, I was throwing up in the men's room before I got up there, and then I froze in the middle of the thing. You know, you get those, you ever had a panic attack where you can't talk and there's a whole audience out there? It wasn't a great day, you know. But what I learned over the years was interesting, and I want to point it out to you because it's a fascinating thing. In a one-on-one conversation, we were over there, we're having a one-on-one conversation. I would not be talking to you like this. I would try to be kind of, low-key, certainly self-effacing, nothing like this, no, assertiveness, because I don't want you to think I'm a jerk. All right? One-on-one conversations, particularly with somebody you don't know, are a lot more challenging than getting up in front of a group of 100 people. And you think, what? Are you crazy? But here's the drill. Okay? First of all, when you get up in courtroom or you get up in a lecture hall, you have the power of the podium. You've been selected, anointed, appointed, what have you, to be up there. So immediately you have authenticity just by virtue of the fact that you're up there. Okay? Secondly, people in groups are different from individuals. Okay? And although we are all, very individualistic, when we get into a group, we tend to really be sensitive to the group. Our antennae go out, and, basically it becomes much more of a group judgment than it is an individual judgment. We're tuned to what other people think. Consequently, a group is a lot more accepting of your behavior and how you express yourself than an individual would be. It's literally easier to stand up here. It's much easier for me to be myself and relax and talk and say what I feel like in a one-on-one, in this conversation, than if we were in there one-on-one. I would be far more concerned about what you're thinking and trying not to be, dominating the conversation or any of those things that alienate people. But here, you're free. You can do all kinds of stuff. Look at entertainers, how outrageous they are. And they get away with it. And then people see them when they're not on stage and are shocked to discover how taciturn and withdrawn they are. Johnny Carson was a case in point. Johnny Carson, Johnny Carson show, he was this dynamic, relaxed speaker, etc. In person, individually, the stuff I read, he was kind of a mean, irritable, non-communicative kind of guy. But you put him in front of an audience of millions, and he was just fine. The audience wants you to succeed. Anytime you're speaking, they do not want you to fail. All of us have sat in elementary school or plays where the kid gets up or somebody forgets a line. Okay? And the kid's up there, the kid's upset. But not as much as the audience. The audience is dying. Come on, kid, remember the line. Come on, Okay? Same thing. Nobody wants a speaker to fail. Unless you personally hate the guy's guts. Nobody wants to see that. All right? So they're on your side in that regard. And you have to be conscious of that. That will liberate you. That will free you from a lot of those constraints, because it's those constraints that prevent you from communicating effectively. And because you're constrained, your communication to them is, and they won't trust you as much. They won't trust what you're saying as much. Writing out summation. If you're relatively new to this, or anybody, purpose of writing out a summation is not to read it to a juror. You don't want anything that you're reading. You want no script. What you want is you want it internalized. One way of internalizing something is writing it. Okay? You write it, and then that doesn't even come to the courtroom. Okay? But by writing stuff out, you internalize it. And even though you're nervous before you go in and you're thinking, am I going to remember this, etc., once you're up, the adrenaline kicks in and everything that you had is suddenly there and you got it. Structure your points for impact. You're trying to make people feel. So obviously we start with the 12 bottles of beer. And then we're going to proceed through there. What is going to be the greatest impact? How am I going to structure this so I get through to the middle, and now towards the end, I want to end with that strength. But you basically, if you've written the whole thing out, you break it down into individual points. At the most, when you finally get up there, if you have anything, it should be a simple list of points. Okay? Framing the issues. That is a huge advantage. In New York, the defense always sums up first, and the prosecutor gets the last word. Is there anybody from the jurisdiction that doesn't have that? The prosecutor gets both bites of the apple, first and last. Okay. But again, the prosecutor is getting the last word. Okay. So it seems like a disadvantage because they get the last word. The advantage, though, here is that you get to go first. You have to turn that into an advantage. And how do you turn it into an advantage? First of all, you do the prosecutor summation ahead of time when you're preparing. It's not hard to do, okay? The beauty of, how many people were prosecutors? Okay. I love being a prosecutor. It was so much easier. First of all, we had evidence and facts, okay? That was great. It was a lot of fun. But putting in a case as a prosecutor is kind of a mechanical kind of thing. The observations of the car in motion, then the stop, then observations in the car. I mean, you can go right straight down. It's easy to do. You don't even need notes in a DWI case. You can just proceed logically. And, you got to really think about formulating difficult questions like, and what happened next? And after that, what happened? What was the next immediate thing that happened? Okay? So you'd have to think about that. But that fact enables you to prepare your summation in a manner that is A, going to make points to the jury, most importantly, and B, really mess up the prosecutor's summation. Okay? Because you're going first, and you know what their summation is going to be. So you can preempt the prosecution. And you preempt them by taking their summation and poking holes in it. Now, as a prosecutor, everything was methodical, mechanical. It was planned out. So as a prosecutor, you're kind of victimized by the plan. Okay? You want to follow that plan, and that's how you go through it. You can run into a defense attorney who messes up your plan. Now you're kind of stuck. So in your summation, you're saying, okay, the prosecutor is going to try to tell you that Mike had a .14. I'm going to tell you to accept that reading. He's not going to tell you is the fact that when you heard the testimony, although Mike was in that room, no one did the 20-minute observation. No one watched him. They were doing paperwork. They were setting up the machine. They checked off that they did it, but in the testimony, you heard no one did it. He's going to tell you that you should ignore that. Okay. Basically, you go through and you frame issues, but you frame them in a manner that now one, that are making the points with the jury, but secondly, you're putting the prosecutor emotionally into a real tizzy. Like, I have a summation. Do I deliver my summation? Do I answer those questions? Can I do the summation and answer the questions? Most of the time, having been in that position, I would try to answer the question. I feel compelled. I've got to answer the questions. But I'm trying to get my summation. What comes out frequently is a real mess, okay, because you're knocked off the plan. So when you're doing your summation, one of the things you want to think about is, how do I preempt the prosecution, particularly if you're from this jurisdiction where you go first and they go last. Very, very helpful. Things that look good on paper frequently do not translate into speaking. You need to rehearse it. You don't necessarily need an audience, but you need to rehearse it. You need to see what it sounds like. Way back when, I would pay kids, sometimes my kids, of course, with them, no amount of money would be enough for them to listen to me. So, I'd hire, their friends or somebody who was desperate for money and come over and listen to a summation and then tell me what I said. What did they actually hear versus from what I said? Okay? And you can do this, you can do it with kids, you can do it with neighbors. I mean, you're going to run through, a lot of your relationships with this, but a lot of people are interested. They're not lawyers, and it's kind of fun, and, it's great, but it's really good to do a dry run so you know, and so you're really comfortable with what you're saying. Paper. Paper. The power of paper is unbelievable. It's, you know that every time you go to a supermarket and you're going through the checkout. Martians have landed. They are occupying, Minnesota. You know that because it says that in the tabloid newspaper that's out there. If it's written, it has so much more credibility than if it's just, like this. Cross-examination. Okay, one of the greatest things I learned, we get those SFST manuals. Oh, by the way, if you want the manuals, for drugs, the SFST manuals, etc., there are all kinds of organizations where you can buy them. If you would prefer to get them for free, the Washington State Patrol, state of Washington, hates providing discovery to attorneys. Anybody here from the state of Washington? Okay. So, what do they do in Washington? They don't provide discovery. They put everything online. You go to their website, and you can download pretty much every manual that's out there. Okay? So you can get the SFST manual, for free. They've got drug manuals. They're a wonderful national resource. That wasn't quite their intention, but that's what they are. Okay? So you're there with the manual. If you ask that witness, okay, now you were trained with this protocol, yes, and they gave you a manual, yes, and I show you what's been marked as Defendant's A for identification, and can you tell us what that is? You are never going to get, oh, that's my manual. That's never going to happen. And the power of the paper is lost. You have killed it. It's like, pulling a bunny out of a hat and shooting it, okay? But if you take that manual, or actually any piece of paper will do, if you take that manual and you look at the manual and you formulate your question and ask the witness questions, and you're clearly looking at the manual. You're not mentioning the manual, not saying anything about a manual, nothing. You just have it in your hand, okay? That witness will give you answers that you are looking for. And sometimes they'll say, if it says so there, that's when you know you really got them hooked. Prosecutor doesn't like it. The objection is, counsel's referring to a document, not an evidence. Being ready for that, it's complete BS. There is no such recognized objection. But it sounds so good, judges automatically sustain it, okay? They just love that. The objection would be hearsay. If you were actually, obviously reading portions of the manual. But your response is, Your Honor, that's not a valid objection. And in any event, if that were the case, then counsel couldn't refer to their yellow pad and looking at questions. I'm referring to this. It might be my yellow pad. I'm not offering any of it into evidence. And the proper objection would be hearsay if I did offer it. Okay? Generally, that shuts them down. Generally, that'll shut them down. But that witness, as long as you don't ask them to authenticate the document, that power of paper is there. Similarly, if you can get a transcript, of particular testimony, so by the time you sum up, you have it, as opposed to simply recounting, your recollection of the testimony. If you have a transcript to read from, it is so much more powerful, because as soon as they see you reading from an authoritative document, that has much more power than simply speaking. So any way that you can use paper has power. Figure out how to use it, and it's amazing. For controlling witnesses, I once was doing a cross on gays, nystagmus, and there's that federal court case, United States versus, somebody help you out. What is it? Warren? Okay, my hearing's terrible. Everybody else heard him. Good. Okay, thanks, Joe. All right. So there's a footnote in there that has all the different possible causes of nystagmus. Some of them are off the wall, you don't want to use them. But a lot of them, excessive caffeine, excessive nicotine, etc. So I'm looking at this thing just to get it. Police officer thought I must have the holy writ, because everything I said, that police officer agreed with, and he was clearly just fixated on that document. And that's when I learned if I can possibly have some kind of a paper, some kind of a document, it gives me so much more control over a witness. Judge's charge. This is all over the block. Some judges will give you the charge. I mean, DWI charges are standard. We have a pattern book of charges, so they're pretty standard, and most of the judges are going to use them. If you're in a state where they don't have a pattern charge, just ask the judge for the charge. A lot of times they'll just say no. If you frame it like this, that, Your Honor, I don't want to have the jury sitting there while we're having a conference in the middle of the trial. Is it possible we could meet, now and basically have a charge conference so we don't have to do it at trial, so it's all settled. So if we do have a conference, it can be an abbreviated one. Basically, it's like prosecuting the prosecution. Typically, we always wait and let them lead, and we're always, we can't delay things. They control the thing, but we're certainly not going to push it. And that works to our advantage until a trial date is set. Once the date is set, then it's to our disadvantage because they'll drag their feet. So what you really want to do is get a conference early on and explain to the judge how you don't want to have stuff last minute. The judge loves it because you're addressing that judge's concerns, and you get the charge. Then you want to get the charge, and you can prepare that so when you use that language in your opening, you can use that language in your summation. So they've heard the judge at the end of they've heard you talk about it, and then they hear the judge give the charge. It's very powerful. Now, the problem with it depends on your jurisdiction as to how much you can get away with in terms of getting into the law. In New York, the general rule is lawyers are to stay away from the law. Counsel, I will instruct the jury on the law, all right? But it varies. One of the things that'll do is when the DA gets into the law, unless it's hurting us, I don't object. I want the DA to set the precedent of getting into the law, and that opens the door for me. So unless it's hurting, I don't want to object. Then when there is any kind of, well, Your Honor, Mr. So-and-so was telling them such and such and such and such, at that point, generally, the judge is going to give you more leeway than you would otherwise get. But you want to work that in. Demonstrative evidence, whatever it is, keep it simple. if you're preparing like, a PowerPoint or anything like that, whatever you're using, make sure, A, you've rehearsed with it, make sure it's going to work. It's really tough when, like with lectures. So when Tony was up here, initially there was a problem with the PowerPoint, okay? That's very, very tough. So if you're going to use it, get there early, get it up, make sure everything's working, have extra batteries, all of that, so you don't have a glitch. I'm an advocate, obviously, of very simple slides, okay? You don't want them, first of all, you want that jury focused on you. You don't want them focused on reading an elaborate slide. You really want their attention. He has to look at me, okay? I have got his absolute attention, all right? You maintain that contact and people will hear you. You talk over their heads or you don't use that contact. The other thing about the contact is that it conveys assurance in what you are saying and how you feel. When people are not comfortable with what they're saying, what they're doing, or they don't really believe in it, they tend to look away. They tend to look away because we all feel like we're, transparent, okay? Like you can read me. If I look you in the eyes, you can read how I feel or I think. And if I'm saying something I don't truly believe, there's a reflexive action. The contrary being when somebody's really looking in the eye and talking, that they at least really believe what they're saying. It may not be accurate, but at least they believe it, okay? The pause we talked about. Veni, vini, vici, or something like that. I came, I saw, I conquered. This thing goes back 1,000 years or something, and they're still talking about it. Okay. Why? Because it's a trilogy. Why are trilogies magical? I have no idea, but they are. They are. So if you can work a trilogy or trilogies into your case, they'll remember them. They're just, famous lines that just capture people's imagination. If it doesn't fit, you must acquit. I mean, people who never saw that trial, nothing, they all know that line, okay? Analogies and storytelling. Human knowledge. Human knowledge is we learn by comparing what is new to what we already know. That's how people learn. So building blocks. With little kids, everything's building blocks, and it's a comparison. So, Moby Dick, this book is like Moby Dick, only it has a shark in it instead of a whale. So if people are familiar with Moby Dick, all of a sudden they now have an idea what this other book is about. It's about a shark that's being hunted as opposed to a whale that's being hunted, etc. So things that you can work in like that. So for example, in this case, there's no 20-minute observation. The defense is mouth alcohol. Okay, the experts testified, the 12 bottles of beer. The experts testified about mouth alcohol and the impact that has, etc. All right? So, and we have these guys who didn't do the 20-minute observation. So, what's the story that we would use? My Aunt Jean was sick, and she went to the doctors, and they said they had to do some testing, but it would probably require surgery, but they'd have to wait for the tests. When she went to get the tests, the regular technician wasn't there, and they had a fill-in technician, and the technician did the test, but they omitted a number of steps. And then Aunt Jean was asked to make the decision, should she go forward with the surgery based upon that test result, or shouldn't she? And she, of course, had a lot of doubts because it was a big decision. In this case, the prosecution is asking you to make a big decision. And they're asking you to make a big decision based upon a test where they got a result, but the steps that were required to be performed, the step that was on the checklist, the step that the Department of Health rules and regulations required, the step that the manufacturer of the machine required, was not done. And just like Aunt Jean, you have to have doubts. And that is a reasonable doubt. Okay? You analogize what is it. They don't know about breath testing, they don't know about that, but they know about medical tests. You do comparisons like that, and it gives people that go into the jury room an argument. Movement. Now, you've seen me up here with a lot of movement that didn't necessarily make a lot of sense. I try not to do that. Paul Homily is a retired dentist who decided to get into public speaking and teaching public speaking and teaching people to be effective public speakers. And so he gave a lecture for the college at Harvard, and I'll never forget, it's funny, I go to these things, and they just stay with you. And that lecture will always stay with me because he talked about movement. And he talked about you stay in one place, you make your point, you talk to the people, and when you're going to make another point, you move, because your movement now punctuates a change in subject or a change in point. So you use movement to emphasize points. Now, it takes an awful lot of discipline because, you are loaded with adrenaline. And it is nervous being in a court. No matter how many times you do it, okay, somebody's life's on the line. It's a stressful situation. And what people want to do is this, okay? They're kind of walking back and forth. They're breaking eye contact, and they are losing their audience, all right? So if you possibly can, try to restrict your movement. Something I'm working on, and I'm not anywhere near where I want to be, but the key is get conscious of it and try to work it so that your movement helps you emphasize points that you want your audience to retain. Handle your problem. What will the DA say? You definitely want to handle your problems, the issues in your summation, and that other part about what will the DA say comes into prosecutorial preemption, is getting down what they said and preempting them by framing issues that they have to answer and that they don't have good answers for. But that's where I turned a disadvantage into a huge advantage by being able to go first. Second seat. You're sitting in court. Most of the time, we're there by ourselves, all right? And when the witness is testifying, on direct, what are we doing? What? You're writing, right? You're taking notes. You're not looking at the witness. You're not seeing most of the communication, which is nonverbal, where they're in doubt, where they're assertive. How are they answering? How are they responding to that DA? You get somebody in a second seat, and they don't necessarily have to be a lawyer. They have to have good handwriting. And you have them take notes. I usually get my wife, Karen, who's an attorney, at the second seat. And Karen takes these great notes. So what do? Unless it's something something is rare that I'm going to take a note. I'm watching that witness. The witness will tell me how to cross-examine them. The witness will do that in the body language and the report. There's all kinds of different personality types. You get the officer who is rigid. They have to do everything right. You get that witness, you show them they did something wrong, and they just fall apart. Okay? I had a guy who was an SFST instructor. Okay? And he gave the instructions, for the one-leg stand. And, stand on one foot, lift the other foot approximately 6 inches off the ground, keeping your hand at your side, counting 1, 1,000, 2, 1,000, 3, 1,000. And if you put your foot down, pick it up. Everybody familiar with that? Okay? That's the instruction he gave my client. That's completely wrong. What's wrong with it? He gave him permission to put his foot down. That's a great piece of cross. Most of the cops give that up. Very few of them will stop and wait for him to put his foot down. What you're supposed to do is if he puts his foot down, you tell him to pick his foot up and continue. You do not tell him ahead of time if he puts his foot down, because you are basically violating the protocol of the test by telling him it's okay to put your foot down, that you're not going to get marked off for that, all right? I crossed him on that, and he was just devastated. He couldn't focus on anything else, and the answers to the questions, that was the end of the case. But you got to look at the psychology. There's the guy who is combative. He's a player. He wants to take you on, okay? He's the one, when the DA asks the question, he gives, a 30-second answer about everything, including the question. The guy who's running his own case, the control freak. But you've got to be free to look at that, pick up the nuances, have somebody second seat you. Clothing store I told you about, the ideas, etc. You take the ones that fit. Critical, critical, critical. I used to try cases with my brother-in-law. So we would be co-counsel. We did a number back in the day. There were homicides together. But what would happen is I would be cross-examining or doing something, and Tom would have a different idea. He's very different. He tries cases very differently. But I'd be second-guessing my own judgment. Okay? All of a sudden, I'm not doing what I feel. And the problem with that is that a trial is like, for the lawyer, it's like a tailored clothing, because so much is dependent on your psychology, your perception, your relation to people. How you frame questions is going to be very much dependent on your personality and your whole emotional orientation. If you have somebody who's second seating you, whose opinion is going to supersede yours, it's like trying to draw a picture with two hands on it. It can't come out right. What Tommy was saying was perfectly valid for Tommy, but it wasn't valid for me. So you have to either be second-seated where you're comfortable disagreeing with the person, or, basically you've got to be comfortable making your own decisions, because they're split-second decisions and they're based upon your knowledge and experience. So it's vital that you trust your own judgment. Most importantly, trust your instincts. Okay, one of the running jokes with my wife is that Karen, we play these different, games, Trivial Pursuit and stuff like that. And Karen will come up with the right answer, and almost every time she will question it and then come up with the second answer. Okay, and I'm always saying, hey, listen, go with your gut, go with your first instinct, and almost always you're going to be right. Trust your instincts. Personal opinion, do not fall into that trap. Do not give your personal opinion during your summation or any point in the trial. The evidence will show, et cetera, but it's not, like the prosecutor coming up against. I've known Officer Smith for 20 years. We've done, I don't know how many trials have we done there, Mike? Like that in front of the jury, okay? You can bet we were moving for a mistrial and all of that. He's vouching for his witness, et cetera. Unless you're a tremendous actor, okay, and I'm not, say what you believe what you say. Okay, if you don't believe your client was sober, then you don't say that. What you say is the evidence doesn't establish that, but you want to be sincere. That sincerity comes across. I know there are people out there that are wonderful actors, and they can say anything, and they look like they actually believe it. But for me, it doesn't work. So I'm always trying to structure it that I truly believe what I'm saying. So, thank you all very much.